Hey guys, I know that you're all anxious to get started with the Sarah Boone trial, as am I. But they are still picking a jury. But from what I have heard, there's some fireworks going on in the courtroom. Sarah Boone wrote something on a sticky note and handed it to her attorney, and he crumbled it up. I don't know what is happening, but Sarah is not getting along with this attorney either. And the state got some discovery at this very late date in the trial. There was a deadline, but Owens is not really been cooperative with deadlines since he has come in so late to the case. And he slapped, now I thought it was 55 pages. No, it was 550 pages of George's medical history. They do not want this admitted. The state does not want this admitted. I think on relevance, I'm not really sure. I don't know if it's just because too late now. How are they going to review 550 pages of medical documents when trial is starting? I mean, they're in voir dire. But why? Now, I know one of the things has to do with the facial reconstruction that George had. She did mention it to the detectives when they interviewed her at the apartment. I don't know if it was on the tape in the plain unmarked police car. I do know that she said it to them when she was sitting on the sidewalk in front of her apartment. So I do remember her saying something about that. The detectives asked her a question, and she did her rambling thing and started telling them about George's facial reconstruction surgery. And I think it was his brother that caused whatever happened. And I think what Owens is trying to do here is just try to get in more evidence that George and or his whole family were violent people. So the state has filed a response to this, and I am going to read it to you. Okay. Sarah Boone. State's objection and motion in limine to exclude decedent's medical records. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. 1. Oh, hang on. Let me see. What is the date on this? Filed 10/14. Okay. Filed 10/14. When was it written? Written on the, was it written on the 14th? Y'all know I have the hardest time trying to find the date on this. Emailed on the 14th. Okay, maybe it was written on the 14th, which was Monday. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. Tonight, the state received 550 pages of medical records regarding medical treatment the decedent received in 2017 and 2018. That was 2 and 3 years before this happened. 2. The defendant acquired these records in January 2022, over 2 years ago. 3. The state adopts all the arguments and authority cited in the state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. 4. The defendant, even in her most recent iteration of what happened on February 23, 2020, has not set forth the legal grounds to claim self-defense. 5. Assuming that she does so at trial with a different version of events than prior incidents of violence committed by the decedent that she was aware of, would be admissible to show the reasonableness of her fear of imminent great bodily harm or death. 6. These records are irrelevant. 487 pages regard an incident on December 24th, 2017, where decedent was beaten so badly he needed facial reconstruction surgery. This is not relevant to whether the decedent committed a prior act of violence that the defendant was aware of occurring. If the incident that resulted in these injuries is somehow made relevant, the severity of the I'm sorry, let me go back and start that sentence over. If the incident that resulted in these injuries is somehow made relevant, the severity of the decedent's injuries is not relevant. If the severity of these injuries is somehow relevant, then the defendant should narrow it down to the pertinent narrative history of what the decedent said happened and the treatment provided. This could be done in a handful of pages. 7. The 2018 incident is also not relevant. The history provided by the decedent was that he put his hands through a glass window the day before, and his wife made him go to the doctor the next day. He received 2 sutures to close a 4.5 centimeter laceration. That's 2.5 centimeters is 1 inch. So that's just shy of 2 inches. 8. Assuming that the defendant testifies in a manner to make that incident relevant, a couple of pages of these records with the narrative of what allegedly happened and the treatment provided is sufficient to corroborate her testimony. 9. Burying the jury with 550 pages of records when nearly all of them are irrelevant, when giving the defendant every benefit of the doubt on relevancy is unnecessary, and the probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence. 10. Therefore, the state objects to these records, barring their relevance being established at trial and their probative value not being substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence. So, there you go. Owens is trying, I don't know what he's trying to do, and I don't know why he decided on the day trial started to get this evidence in. I don't know, but they are supposed to have a hearing in the morning about this and the motions in limine, and my dog wants pork chops. And I will be covering it, so I will see you guys in the morning. Bye.